He laughed, not nervously, not the uncomfortable laugh that slips out when a person doesn't know what else to do. He laughed the way people laugh at something genuinely funny, head back slightly, a real exhale, the kind of laugh that says, I find this amusing, and I don't care who sees it. The thing he found amusing was his father's diagnosis. Stage 3 liver failure. 18 months, the doctors had said, maybe less. And his son, sitting 3 feet away, in a suit that cost more than most people make in 2 months, laughed. The courtroom went completely still. I have been on this bench for 4 decades. I have watched people do things in this room that I did not think human beings were capable of doing to each other. That laugh is still in the top 5. Stay with me, because what happened after that laugh is the reason this case still comes up when I think about why this work matters. And the reason I am telling you this story now, years later, in a format like this, is because the man who laughed never expected to be remembered. He expected to win, walk out, and never have to think about his father again. He was wrong about all 3. The plaintiff's name was Howard Bellamy, 74 years old. He had built over the course of 42 years a small but successful commercial printing company in this city, the kind of business that never makes headlines, but quietly underlies half of what a city produces: menus, brochures, event programs, the physical paper trail of other people's lives, printed with care and delivered on time for 4 decades. He had started the company at 32 with a single machine in a rented space, a business loan that took 11 years to fully retire, and the specific kind of stubbornness that doesn't know when to quit. He had worked 7-day weeks for the first 4 years. He had taken no salary for the first 18 months. By the time his son Marcus joined the business at 26, Howard had built something real: 12 employees, 3 major commercial contracts, a reputation for quality and reliability that kept clients coming back without a single dollar spent on advertising. He had brought Marcus in deliberately, gradually handed over operations, stepped back the way fathers do when they've built something and want to see it continue. He had put Marcus's name on the ownership documents at 65 in what his attorney described as an early transfer of interest designed to simplify inheritance and reduce estate complications. That document, signed with good faith, handed over with love, was the instrument Marcus had used to take everything. Over the following 4 years, Marcus had systematically moved the company's assets, equipment leased against the company's credit to a separate LLC Marcus controlled, contracts quietly renegotiated through shell companies Marcus had established, cash distributions redirected through accounting adjustments that Howard, who had always trusted his son with the books, never questioned until the business bank account showed a balance that made no sense. By the time Howard understood what had happened, the company he had built over 42 years was an empty shell with his name on the letterhead and Marcus's hands on everything inside it. He had gone to an attorney. The attorney had filed the case. And Howard Bellamy, 74 years old, stage 3 liver failure, 18 months on the clock, had walked into my courtroom to try to get back what his son had taken. Marcus Bellamy arrived at 10:03, 3 minutes late. No acknowledgement. He was 44 years old, well-dressed in the specific way of someone who has recently acquired money and has not yet learned to wear it without announcing it. A watch that probably cost more than a decent car. Shoes that were too new for a courtroom. The kind of unworn leather that says these were purchased recently, specifically for today, which is a kind of performance that reveals more than it conceals. His attorney was a man named Gerald Frost, experienced, efficient, who had clearly been briefed on the case thoroughly and understood the documents well. Frost would be difficult to argue against on the technical merits because Marcus had been careful. The transfers had paperwork. The lease agreements had signatures. The shell companies had been established before the transfers began, which meant they predated any dispute and therefore appeared, on the surface, as legitimate business structures rather than instruments of concealment. Marcus had built a legal maze around what he had done. He had not accounted for one thing. I will tell you what that thing was, but not yet, because first I need you to understand what it felt like to watch Howard Bellamy take his seat at the plaintiff's table. He moved slowly, not from nerves, from fatigue, the specific fatigue of a body that is working harder than it should have to work to do ordinary things. He sat down carefully, with both hands on the table's edge for support. The way people sit when sitting down has recently become something that requires thought rather than happening automatically. His attorney, a younger woman named Patricia Chen, who had taken the case on a partial contingency because Howard's available funds have been largely depleted by Marcus's transfers, placed a hand briefly on his shoulder before sitting beside him. Howard Bellamy looked at his son. Marcus did not look back. In the entire 90 minutes of that hearing, Marcus Bellamy looked directly at his father exactly twice. Once at the opening, briefly, with an expression I can only describe as dismissive, and once at the end, for reasons I will describe in detail, for much longer than he intended to. Patricia Chen presented the case methodically, the original ownership transfer document from 2019, the company's financial records from 2019 through 2023, showing the progressive asset depletion, the LLC registrations for the entities Marcus had established, all registered to a home address that was Marcus's own residence, a fact that, when combined with the subsequent transfer of company assets to those entities, was not subtle on close examination. She had a financial forensics expert whose report ran to 64 pages and whose conclusion was clear. The movement of assets from Howard's company to Marcus's personally controlled entities had been systematic, documented, and not consistent with legitimate business operations. Gerald Frost's response was competent. The transfers were legal. The LLC structures were legitimate business entities. The lease agreements were properly executed. The financial movements reflected genuine business decisions made by a co-owner with authority to make them. He was right about all of it, technically, and he would have won, technically, if that had been the whole picture. But Patricia Chen had one more exhibit. She had submitted it the morning of the hearing, under a motion I had allowed after reviewing the nature of the evidence. It had not been included in the original filing because it had only been discovered 11 days earlier, when a former company bookkeeper named James Otero, who had worked for Howard's company for 9